Good evening. We'll call the City of Norwich zoning board of appeals for Tuesday, May 13th. We'll call the meeting to order at 7:03. Roll call. Dave Martin.
Present.
Ed Aberbach.
Present.
Bob Phoenix.
Present.
Dottie Travers. Present. Mark Benjamin present. Also President Rich Shuck and Catherine Rose, staff. We do have a quorum. We can conduct business. 5 members. So we'll be seated. Communications.
The communications that I passed out here earlier was the draft settlement agreement that I had passed out and emailed.
They've been entered as exhibits.
No, well, there's no exhibits.
Okay, but
Not
you've got-
public hearing. Yeah, and then a letter, email from the association's attorney to Attorney Block. That was spoken to.
Acceptance of the minutes of the April 22nd, 2025 special meeting.
Motion to accept the minutes.
I second.
22nd.
Errors, omissions, and corrections.
My last name. Second, paperwork. My
Okay, that's totally correct.
corrections,
So your motion is to accept as presented.
correct.
That was your second. All those in favor of accept as presented? Unanimous?
Aye.
Unanimous.
Aye.
Motion carries. Minutes accepted as presented. Old business discussion continued from April 22nd, 2025, meeting of Forest Land Investment LLC versus the City of Norwich zoning board of appeals. So we see the settlement agreement. And then the letter from the attorney. Has everybody had a chance to review that yet?
The process.
Okay. Or draft settlement agreement? Okay. The draft settlement agreement, settlement agreements. And while you guys are going through that, the other thing that Attorney Driscoll presented just prior to the meeting, by Connecticut statutes under section 14.7 BJ, we did not announce last month that we would be voting on this tonight, so we cannot vote on this tonight.
That's not a statute, that's a practice book.
Oh, okay, a practice one.
It's
I'm
a
taking
rule-
code
it's a-
right
it's
now,
a
so
rule
it got
against-
carried in statute, so I. Thank you. But regardless, on advice of this practice book and Corporation Council, we will not be taking a vote. Okay, good. All right, thank you. So I know you guys had a deadline coming up. So,
We have a report due tomorrow.
okay,
The judge is gonna ask what the status is. What's remote, so.
Okay.
No hearing.
status is we're obeying the practice book.
Yeah. Try and.
Driscoll, I have 2 copies of a settlement agreement proposal. One is dated April 22nd, the other one is dated May 11th. Which one is current?
On the May 11th is the more current.
Thank you.
May 11th is the draft. Doesn't say draft, but draft it is. Understood, yeah. It's not a settlement agreement unless signed to settlement.
Good.
Oh, I was wondering if I had copies of that, okay. Yeah, it's cool. I was wondering if Sabrina should copy, took care of that already.
I didn't need one.
Turn interest.
You'll appreciate it.
Okay.
Ready for it?
You all set? Yep. And you good? All right, so we have another draft in front of us. And Bob just asked which one was the May 11th or the June. Elaborate on the difference. Oh,
The May 11th is as far as we've gotten so far. And there's also one that we have attorney right dated today.
right.
Those are the two current documents as far as.
From where we were last month and today, what's the difference?
The difference is let Mr. Wright in. Okay.
Good question. People
Coming in now, it's like. I'm sorry, you may proceed.
I'm sorry, what I asked Attorney Block that we have the settlement agreement from last month that we were presented with. That we hashed out, we discussed, and now we have another one tonight with a different date on it. And I was asking what has changed? You know, what's the difference between those two settlements?
I can give you a bit of background. Last month, Attorney Wright and members of the association. At the hearing, we got involved in a discussion in regards to possible changes to Forest View Estates that might satisfy the association and unit owners and be acceptable to the appellant. The intention was when we adjourned that the association and my client would somehow have a discussion and see if we could arrive at a common ground to resolve all of the issues that were not necessarily part of the variance application, but were part of overall issues involving Forest View Estates going forward. Unfortunately, there was no meeting or discussion between my client and the association or myself, Attorney Wright, until I received the letter which you have before you from Attorney Wright, which arrived today. I then took the settlement agreement and eliminated from it provisions that would have bound the association to certain changes that might be made as part of the appeals process or the variance application process, and just left it to be that this board would be granting a variance. There's nothing in there that binds the association. Matter of fact, says specifically that the association preserves all of its rights under the declaration, under Kiowa, and by law. So that assuming that this board granted the variance, the association would still have all of its rights to object to any plans that the declarant might file, might attempt to file, or any application before the CCP or this board. So all that we could end up with as part of the settlement would be the granting of a variance. It doesn't give us a right to build, doesn't allow us to do anything, except that the land would then be subject to this use variance to allow the use for residential, which is board now. And that's the only thing that we asked for in this application. So not having heard from the association and having had no discussions and being faced with a Superior Court hearing or status conference tomorrow, we wanted to try and bring this matter to some possible conclusion, knowing that if this board didn't accept, had the ability to vote tonight and didn't accept the settlement agreement, what we would be left with would be a decision by Judge Chadwick to the pending appeal before the Superior Court. And that's where we are. So, so the settlement, the only thing that's lacking in the settlement agreement that I need to amend is to add some consideration to it for the board granting this. And we were going to propose perhaps installation of walking trail at some place that the city or the Commission on the City Plan might determine is appropriate, that my client would build at no cost to the city in consideration of the settlement with the board.
You also have a question before
I'd like to say this
I?
one.
Okay, hold on a second.
Okay, if I could just supplement what I was saying.
Yeah.
I just want to make it clear that the only matter before this board is the application for the variance. There's nothing else before this board, and while the association has a perfect right to appear and speak, that there's nothing before this board that would give the board the power to grant anything the association might ask for, because the only thing that's here before you is the application for the variance.
100% agree.
No,
Um,
I'm not sure I do.
Well,
Are we allowed to add conditions?
we are allowed to add conditions based on testimony we take. You know, we are here to hear this. And we are gonna take all the consideration in. But some of what is concerning, I think, to myself, and I know the other board just by looking at their faces, we made some suggestions to you that we don't see reflected. So that was disappointing to read. Is that fairly accurate?
Quite accurate.
Yes.
Yes.
So agreed that this is one thing, but what was given last month, we were hoping to see something else.
Got a walking track. Maybe
That was discussed.
You are-
Yeah, it was
Yeah, it
discussed.
but it wasn't included,
I understand.
so we were an incomplete document for this.
I do have one question. It's talks about 25 units. Wasn't last week, wasn't it 20, wasn't it 24 or something like that? What's the,
Correct.
do you know what the
So,
difference?
so we just got this or I just got this yesterday afternoon. I didn't have a chance to kind of reflect and check it on accuracy of all the dates and approval dates and everything else. But it did jump out at me that 25 is in there. The last approval was 24 units. Which was the modified approval. And the plan that we handed out last.
I think I'm just gonna go to Attorney Driscoll, and then we'll go around the board to those two, and then we'll take Attorney Wright. Attorney Driscoll is the city attorney. And I almost hate this question. That's about sums it up.
Well, I think so, just my way of background, I could probably touch it before. The case was tried in November of 2024. It was briefed, argued before the court, and the court then took papers, meaning the court
Right.
had the right decision. Unusually, we got a call a month or so later for a status conference. Usually status conferences for the case ten. Working out, ready for a trial type of thing. So went to the status conference, the judge raised questions that he had about the law and about the case. He, suggested that we might try to see if this could come to an understanding. We've had, I think, another one, maybe two total in addition to that. The judge is supposed to run your decision for 120 days of finishing the trial. And both parties, the city and the opponent, waived requirement for time period. So judges keeping his eye on the case in the sense that schedules, a judge is scheduled every month to get reports as to what's happening. So for this recent time, for the special meeting here, we're going to have the special meeting tomorrow. Report to the court. And the judge's name is Chadwick, and the judge is currently handling this area of any type of land use appeal is another judge. Whether Judge Chadwick is going to be specifically handling this, or whether that other judge is going to ask to report to Judge Chadwick is something to be determined. That's kind of where it stands at this point. So, taking the city's point of view, it's up to the board to make its decision based on all the materials and evidence and judgment should have on this. And the appropriate time, which unfortunately is not tonight. There's been some discussions today between both sides. You know, keep in mind, zoning and use, Black pointed out, different from public interest ownership. They have different sets of rules.
Right.
I do with the tiger and the shark. They just,
Yeah.
they have their own areas.
Right. Like I said, I'll probably just let the board ask the two attorneys questions, And then I agree with what you both said, but I think I'm almost gonna treat this as abutting neighbors to the other people and allow them at least an opportunity, whether through council or individually. You can't vote on it tonight, so there's nothing wrong with getting additional information. Because I know a number of our concerns are probably gonna get echoed. And I feel he's a budding property owner, have a right to say something. So, anyone that disagrees, I agree with that.
No, I agree.
Right,
In fact, I'd rather hear them than ourselves.
yeah.
Well, I certainly would like us to, as operate just like a normal, variance proposal. If we have questions, that would be our opportunity to ask.
Let me raise one more thing then. One of the issues the Judge did raise is a question of whether this was the best way to proceed it as opposed to another method that's
Right.
available. So the question that leaves unanswered is if the judge were to decide the case adversely, is there still a right to bring another claim? That's sort of the loose question that's out there too.
I'm throwing it back in his lap, he decided I didn't have to.
Yeah.
Any questions, Adam? Dave? Nope.
I guess I've got some questions on, I understand they may not be related specifically to zoning issues, so I don't know if that's a good thing. I'll go ahead anyway and see what happens. I was reading the minutes and I see towards the end, it says, Attorney Block stated there were also declarant right issues between his client and condominium associates that needed to be figured out. So, at the last meeting, you said, basically what I'm getting out of this is recognize the fact that there needed to be some discussion between then and now. What I'm hearing is that discussion never happened. So that's disappointing. The condominium group actually had a meeting and they actually came up with specific recommendations and suggestions, and they even prioritized them. So kudos to them. There was discussion also about the density of the condominium. That's 24, 25 is what numbers out here at the moment. We had talked about maybe 12, 10 being better for the community. That was our feeling at the time. That hasn't been addressed at all from what I can tell.
We made an effort to contact the association and its council. We didn't hear anything till today. So there was, I'm not blaming anybody.
Yeah.
It didn't happen today. So we didn't discuss the density. We didn't discuss some of the other issues that are raised in the attorney rights memo.
I'm going to address some of it on this week. Yes. Since we can't vote on this tonight, I guess the big question is, will this communication between the students happen next time?
I don't think it can. You have to go to court tomorrow.
We're just reporting to the court.
And
The court, going to the court is going to require us to say it's resolved. I just want to know, is it moving?
So in the picture of what this board is sitting here for, the members of the association, they have a vested interest.
Yep.
At the end of the day, and correct me if I explain this wrong, Attorney Driscoll, but at the end of the day, the appeal is the decision that was made. Everything that is the wish list, and I say this respectfully, the wish list of the association is irrelevant. It's between the board and the applicant.
Yeah, I get that. That's why I said I
Right,
wasn't sure
so-
about these questions.
And I'm going to caution the board to be very careful when discussing the wishes of the association. I mean, naturally, you're gonna look at that, and most of what was in that letter was stuff that was previously discussed. You know, unfortunately, it's been a little unconventional. We have a third attorney who is representing the association, who is interjecting opinions into the discussion, which can lead everything awry. So I'm just asking to stay focused on the discussion is between the board and the settlement with the applicant.
And to Rich's point, some of what is in this list is outside of our
I understand.
purview, you know, and I don't fault the association for asking for it. And no different than if somebody were on a budding neighbor wanted a shrub line privacy so they didn't see the headlights of somebody parked, you know, if they were gonna put their garage closer. And something like that is a reasonable accommodation, but some of this is way outside of our reach.
Yeah.
But it's stuff to take into consideration as we're looking at the whole thing and how does it affect the neighborhood.
Yeah. I have one last question. In the draft proposal, number 2 at the end, it talks about enforce the terms of the Declaration of Forest States. It's, I'm not good.
That's the
When the-
controlling document. that
when
goes
the-
in there.
community was created, whoever formed the community at the time filed a declaration in the land. The declaration operate, take that property, subject to the condominium act. And that's what that refers to. There are certain requirements, for instance, the number of units. We're asking what the number of units, we're suggesting. Well, the declaration says there can be up to, I think it's 48 units up there. That's what the declaration said. So in order to amend the declaration and change that, there are certain procedures that the statute mandates. They have to be met by the declarant and by the association. So it's like having a set of bylaws that you have to operate.
Okay. And again, I assume most likely not a whole lot to do with zoning.
Now, one thing Attorney Driscoll and I had discussed, this is a very strange case because you have zoning on this side and you have condominium law on this side, and they don't always agree. So some of what you're suggesting is appropriate from a zoning standpoint and might be part of a site plan that's ruled on by the Commission on the Scenic Plan, but has very little to do with whether a zoning variance should be.
I think our ultimate goal here, just from talking to members individually, was to come to a reasonable accommodation or a settlement, to get this out of the courts, get it out of litigation. So I think that's what we're all here for. We can see something should happen, but it's gotta be reasonable in all parties. So, and if it has to go through the courts, there's plenty of ways this can get solved. You know, it's not up to us to solve every issue in front of us. But if nobody has any other questions for Attorney Walker Driscoll, I'll offer Attorney Wright the opportunity.
I'll try to be very brief. We found out about this through a friend of a friend. On that first meeting that I attended, that was the first meeting that we were able to attend regarding this issue whatsoever, because we had not been contacted. I'm not saying that by law he had to contact us. I'm not saying that he violated the law by not contacting us, but contacting us earlier, this is the case been going on since 2022, would have given us more time to negotiate if he thought that was important. Now, as far as the meeting, we have a bunch of members, bunch of people that live there that this all affects. And they had to have a meeting. That meeting happened on May 8th. Then they had to get all together everyone's opinions on a piece of paper and then send it to me so that I can make sense. If you read the document, you'll see that it was meant to be an opening salvo. These people are not engineers. They don't know what it takes to build a building. No one knows what it takes to build a parking lot. We were asked for a wish list, and that's what we gave them. And at the bottom of the wish list, we said this is an order of priority, and we know we're not going to get everything. We're probably not even entitled to much of it. But these are things that are wrong with the property that need to be fixed if you're going to build more. I would like to say that some of the stuff that we were concerned about echoed your concerns, less density in the development. Top concern, number one.
Yep.
Involvement in the HOA. You put that in because these people are going to be part of the same HOA board. I sent it to them as soon as I could. I had actually been trying to get them to have the meeting as soon as possible. We got late notice of this stuff. And we didn't have time to research the correct way to join the case because we weren't invited into the case. We weren't told about it at all. It appeared as a declaration that wasn't authorized. So we sent that out, and the response we got was, the association is not a part of the settlement. It is not impacted by the settlement. The problem is that I have a bunch of people here and on the screen that think they are impacted. I suspect that some of you think that we're impacted. I would say that that's substantially untrue. But it's meant to, and now to come here today and say, well, we just want the variance, forget about our whole building plans that we told you about before. It's almost like they want to forget the people who actually live there. And these people thought it was important enough to actually show up for this. So I know this may not be your job. It's been said many times before that this might not be the right place for this, but we weren't invited to the right place. So these people are making an appearance where they can. They can be heard by anybody. And before, to his grace, Mr. Block has talked to me outside and he wants to approach mediation. I think we're leaning toward that. I told him I would talk to him after the meeting. But we're not here to block anything. We know this is not up to us. Like, we know that there's higher powers making decisions here. We just want to be heard. Now, I will say that the majority of the residents are against this as proposed, but we just got this new proposal today, just as you did. Yeah? And, you know, we have every intention of meeting him. Our whole plan was to send him a wish list, come together and hack out what can actually be done with it. If anything, hey, we might only be able to get one or two things. But that's better than getting nothing and getting a development imposed upon them with no say. That's all. That's all I have to say today, sir. Thank you.
We are totally off the radar here. I open this to public comment, or do I?
No, I mean, in general, I think the public the public wants to be heard. You know, and I'll echo what I said before. You know, this settlement is between the city and the applicant. And I can speak for the board. Every member of this board respects the wishes of the members of the association. But this board is not, in my opinion, opening the association up to anything that wasn't in their declaration. You know, so we don't want to go too sideways. And the last thing we want to do is muddy the waters anymore with legal questions because everybody's throwing out opinions. And I'm speaking as a layperson. I'm not an attorney. I just know how it can go sideways, you know, and it's like I said before, it's unconventional that we have a meeting for a settlement between the city and the applicant. It's kind of unconventional that we have the public and a representative, and I'm not saying it's wrong because the public wants to be heard. This is a public forum, but the public's opinions, while it can be considered, it's going to be considered human nature. They're going to think about it. It has to stay focused on what is actually here, is a settlement of a lawsuit. Irrelevant to what people want, it's the merits of what is asked for. What's the lawsuit? What's the settlement?
We're just hoping that
Right.
the people involved in the settlement will listen to the people that actually live there.
Right.
Sure.
No, and they understand that. You know,
Does anyone on the board have a problem with allowing testimony?
No, not at all.
I would impose the 3-minute rule.
Oh, definitely. Please,
So-
And please, don't get me wrong, the reason I say that is we have a lot of people here. And I want to make sure everybody does have an opportunity. But we need to keep it within a reasonable time.
And I'm done talking, so it's.
And what I'd like to ask is you name an address and understand we have the suggestions proposed by your council. And kind of keep in mind, we're with you on hearing density, parking, other concerns. But some of these HOA things, it's not within our powers to do that.
Understood.
So I'm asking you guys to use your time appropriately. State your concerns and not make it they didn't pick up the trash, or they don't do this, or they're not a good landlord type thing, because that's really not, this isn't the place for that. We want to offer everybody the opportunity to voice your concerns as a neighbor to a development coming into your neighborhood. Whether you feel it conforms or what's going to make life better for the whole community up there. Because this is totally off the charts, what we're doing, and we originally denied this, and the courts and through attorneys, it's getting suggested get approved. So this could be in litigation for years and still get approved. We're trying to make the best of a very tough situation for everybody. Nobody wants to, this isn't a win-lose. Everybody's gonna eat a little on this one tonight, including us. I stood behind my decision for a couple of years that I denied this claim, and I have no problem saying I denied it. And when the judges are coming back saying, hey, you guys gotta look at this again, we gotta look at it again. So we're gonna offer you that opportunity, and we're not gonna sit here with a stopwatch, but try to be considerate of everyone's time and keep it on task, is what I'm gonna ask.
I think, okay, so.
Yeah. I just want to. Good evening. Oh, Suzanne Colaluca, I'm at 59 Forest View Drive. And I just want to speak directly to the variance, which is exactly what you guys are working on here today. I don't want to talk about all the other stuff. You have our list, so you know the rest of it. I've lived in Forest View for 20 years. I was one of the first people to move into the lower level of the development. We have some people here that were in the upper level before me. The declaration at that time did say that we were going to get 24 additional units. I bought with that impression that that was going to happen, and I accepted that consequence. As the developer went bankrupt and the new person took over, time passed. I also knew that there was a 20-year time limit on the variance, and I mean on the building rights for our property. That 20 years expired, and I really believe that was all we were going to see of this. It's now come up that they're trying to re-establish their building rights, but in addition to that, in the meantime, the town changed the zoning. So we've got the building rights that expired in 20 years, a couple of years ago. And in addition to that, the zoning doesn't allow residential in the park anymore. So for that reason, I wanted you to hear my impression of granting a variance, because I think that he lost the opportunity to build when the 20 years expired. So that's just where I'm coming from on this. And all the other stuff is really dependent on what your decision is, and we'll respect that decision. And as you can see, we're willing to work with it. But it seems a moot point to me, because the building rights expired 20 years and they were gone. So now we're reopening an old can of worms that seems like it should have never been reopened. So that's just my opinion.
Thank you. Thank you. Before you sit down, may I ask, was that part of your declaration?
Yes.
It was.
If
Thank
you
you.
look in our declaration, there is a plot plan for an additional 24 units. But the building of those units was restricted to within 20 years of the date of the declaration. and that expired.
Thank you.
Thank you.
Name and address,
I'm Georgette, I'm, unit 5.
your
up on
last name as well?
Page.
Thank you.
So, just a couple things.
Your address again, please? Sorry. Unit
Your address.
5?
Oh, I'm number 5 at Forest View.
Okay, thank you.
Oh, I lost it.
Oh, sorry.
Oh, well, I just found out about this meeting yesterday, so you would have had a lot more people here at Forest View. I want to ask, when you guys make these decisions, do you actually go to see the area? Get a better feeling?
Yes, and sometimes yes, sometimes no, but we can't go as a group. We have to go individually, because if we go as a group or a quorum, that's another whole problem. So we go up and, yeah.
I do.
Anybody else?
Kathy Rosen, 7 Forest View. I think 24 units is way too much. If you look at our property, it's too much. I'm a newbie. I just bought my condo last July. I had no idea any of this was going on. I would have never bought my condo there if I had known that. I bought my condo because of the beautiful, it's a very aesthetically pleasing spot. The industrial park has what, 5 different complexes in there. They're all on top of each other. If you go into Forest View, they're not on top of each other. They have a nice space here, nice space there. We have green space that kids can play on. Everywhere else in the complex, they don't. I'd hate to lose that. I'm right against that green space. Children play there, they play ball with their families. If there is a condominium right next to them, I'm looking at someone's living room. So I would appreciate it if you did not build 24. I think you have conditions that you can go through. That's one of the conditions. I would really like you to go look at that space, because it's not, you can't, it's too much. 24 is way too much.
And Mary?
Yeah, I just wanted to add one thing. My name is Mary Rouse. I live at 56 Forest View Drive. I am on the association board as well. I am the treasurer. I just want to mention just the nature of this whole thing are happening upon the information, not being informed, not even being talked to or approached or discussed. The developer does in fact own 2 units within our community, and we were not even brought into any kind of discussion. Secondly, our discovery came when we discovered that a declaration amendment had been recorded with the town, and we were not even informed. And so that to me is concerning with regard to the delay in recording of an amendment to show or establish an intent to build on our property. And I would just like to mention as well, it was about 6 weeks before the expiration of those rights. So it just goes to speak to the nature of the kind of underhanded and around us mentality in terms of the building stuff. So that's it. Thank you
Do
very much.
you know approximately when that amendment was filed? Date?
It was July of 20.
Their rights were set to expire, I believe, in August of 2022. It was filed in July of 2022. That's the best, to my best memory. It's about a month before the expiration.
You know that amendment involved the expiration?
I believe that it was a clever way to save the project.
That's kind of one of those, like, not picking up the trash.
Not a something thing.
I'm
sorry.
I'm sorry,
I'm
but.
sorry.
I
I'm
just want
sorry.
the point to be
Yeah.
noted, that's
Yeah,
all,
sorry.
point to be noted,
Yeah.
I
that
didn't
that
mean to-
board was not involved, the
Right.
association was not involved or notified in any way.
Is there anyone else? Don't take it as any disrespect. Yes.
Just remember, it's called Forest View Estates. For a reason.
Sorry, I didn't mean to get into that, but
No,
I do understand the depths of declarations, and that's gonna be important in my decision.
Is there anyone else in the audience that had anything to say? If not, I thank you all for coming out,
Okay.
expressing your concerns.
You're gonna go to an executive meeting now?
No, we cannot vote tonight.
Okay.
So, this is gonna get pushed again till next month. I'm gonna offer Attorney Driscoll and Block an opportunity to speak at anything else that they heard. If there's anything else you'd like to add, and then the board may express some concerns to the attorneys.
Yeah, probably. I think I can
Okay.
speak. It's possible to have a special meeting, not going to June. This is essential.
I would suggest that. Because the June meeting's gonna be pretty heavy. Agenda.
I'm not opposed to that at all, but I'm just wondering if that makes sense to have that special meeting.
Yeah, we just closed.
It can't be closed, but we can't, if we close it, we can't take any additional testimony, so the vote would be open to the public, but nothing else could be taken. So,
Thank you.
Thank you, guys. We could do a special meeting sometime now. When would you suggest?
We do refer to mediation now.
If you don't have to,
We'll push it out,
push it.
so, that's next week.
Mhm.
I don't think
Next
I,
week?
well, Memorial Day weekend's the following weekend, right?
Yeah.
On Monday.
So-
After.
I would say I think we're gonna have to go after that. Just, I know what my next week looks like.
You could stay the 13th, and Memorial Day's the 26th.
Right.
Right.
Pick a date.
Tuesday after. Memorial.
I'll be away. I'll be away between Memorial Day and June the 16th, so. I may be able to get somebody else to sit in.
Okay.
I don't know.
If you go to mediation, you have nothing to do with zoning.
Meeting again on the 10th.
Doesn't have to be.
It's a second date from actually.
Okay.
My next Wednesday, the third, I'm shot.
So
Okay.
is it possible you go to arbitration? You would go to mediation. Just
If
set
it's
something-
next Wednesday, would it be at 7 o'clock?
It will not be next Wednesday.
Okay.
If
I
you
just-
want me there.
If I can't be there, I think I have to find you a replacement. I do have a
Okay.
meeting, so I just need it. If it's the following week, I could do any day, but. Yeah, I'm like you, next week, there's like a meeting
Right.
every single.
Yeah. Wednesday and Thursday, I'm shy.
So we're looking at the 27th through 30th.
Attorney
Blocks
What? 27 through 30th?
I mean,
would be the first
I could
available.
possibly do the 20th, just,
I can't.
Okay.
I have a meeting. Covered.
and I think you're just trying to accommodate the courts, correct?
Oh, yes and no. That's one of the, basically also to show that there would be a decision to make. And yet you have the information to make the decision.
Can we give them an answer of, due to conflicting schedules, this is moving? And
I
it's,
mean, we could advise the court that the commission met tonight. We're able to vote tonight.
Right.
Trying to set up a date to do it. If there's some health related issues that may come into play.
right.
Just push it off till the 10th.
So Attorney Block is off through the 16th of June, he says, yeah.
Oh.
And I would really like to have Attorney Block president. Thank you.
That work. Yep.
Yeah.
Well,
I mean, if it's gotta go, if between his schedule and mine, if we can push it till after the 16th, I would like to do that.
17th too soon?
June 17th.
Is 17th too soon if you're coming back on the 16th?
Get off the plane and come here.
You want me to pick you up?
You make the 17th, then I'll make it.
17th.
I think I'm good.
So we'll have a special meeting on the 17th. That's Tuesday. Yeah. So we get to see each other 2 weeks.
Any questions for?
Can we add any? Can the board actually add any restrictions to this? That are zoning related type issue?
Zoning agreement,
As-
you have the power to,
Right, as in, you know,
the idea of a settlement is that there can be conditions to the settlement.
Right.
You made a decision, you're being asked to leave a settlement that undoes the decision. And it has to be nurtured, but it has to be limited to things that are germane to zoning.
okay,
So that would be.
So that, No, frankly, conversely,
Cut to the chase.
one of the things is just the potentiality of another suit. Sure. Costs are involved. And there was some, I was zoning or not, but the agreement is certainly done. Not so much that you insisted that is, but that's often you find. Very,
Any block?
I don't have anything to add, but okay. Thank you for moving your schedule to accommodate.
I would. I know you understood it last month, and I'm not, and you get it now.
I get it now.
Come up with something a little less invasive, show some parking. Show some parking concerns. I think that's within our purview to say, and show some green space. What the HOA and some of the stuff, everyone in this room knows what we can and can't touch. But as I said before, I don't like seeing this again. I agree with one of the statements. I voted against this thing. I'm still not in 100% favor of it. And I'm gonna eat a little crow on this. I'm only eating a little. Everybody else feel the same, echo?
Can we also say show less density, or is that
yeah, the density in the parking.
density and parking?
And the trail that he's already talked about, I think those are the things that we can.
That we can relegate.
Right.
And,
You can also relegate building positions.
Yeah,
Placement
True, but then we have to get,
is setbacks.
but we have to get a map out, and we have to do a lot of work to make sure we get the details right on that, and that will be very hard for us to do.
Yeah, because
There are existing setback rules, I'm sure, in the zoning laws and the zoning rules.
I mean, it's an overlap where your authority doesn't really apply, in the sense that you have to approve a certain density.
Right, so-
Measurements and this and that.
So the multifamily regulations with the requirement of 30-foot separation between buildings would apply. And any setbacks to the property lines would apply. There would be no reason for the board to go above and beyond to put anything other than what's in the regulations.
I mean, I talked to Rich this afternoon when he told me to look for my emails. We could still end up with the same number of buildings with the same square footage. It's only 12 units, but they're all 4-bedroom.
Right.
Which would not, I wouldn't be impressed with that, but he answered the question I asked him.
Yeah.
So,
Well, so we need to be a little,
just cautious of what be cautious of what we're asking for. 4 bedrooms hurts the school system. 2 bedrooms don't. you know, so maybe 1 or 2 bedrooms bigger or something, you know, and afford, everybody in the room knows what our concerns are, so. And I understand the developer, we know what his concerns are. So, sure.
And I'm just gonna throw this out there. You threw out a walking trail, which is fine, which is great. The back part of that property, and I don't have the maps in front of me, but the back part of the property has a lot of wetlands and there's a conservation easement back there, so I just don't want the developer to promise something that he can't provide because there may be restrictions in that conservation easement or something else in the back of the property. So I'm just,
So stopping to be germane, but on the council agenda for this coming Monday is pineapple culture to sell 230 Ferguson Avenue. Where that isn't proximity to this
Right.
It's available.
Anything else? Motion to continue.
Motion to continue, the hearing on Forest View Avenue until, first available special meeting time, special
special meetings.
to be held on the 17th of June.
To include a vote.
To include a vote.
Thank you.
Driscoll to make sure
I'll
the
second
agenda
that.
is,
Those in favor to continue?
Continue, Phoenix side.
And everybody.
Dave Martin, aye.
Mark Benjamin, I unanimous, continued. Staff updates?
no, next regular meeting is looking like it's gonna be a full agenda.
Motion to adjourn?
Phoenix motion to adjourn.
I'll second.
Those in favor?
Aye.
Unanimous, meeting adjourned 8 o'clock.